Then I'll take rule 39, rule 29. Rule 29 is change of counsel. Change of counsel. It is not out of place for the client to be dissatisfied with representation. It is also not out of place for his friends to market another lawyer to him. It is right. The Constitution says that a lawyer of his own choice. There is no hard feeling. Tomorrow, you could be the lawyer of his own choice in another matter. So relax. If the lawyer is no longer satisfied with your representation, no problem. What is left for you is your fees. Now, when a lawyer changes, when you are the one changing another lawyer, when you are the new lawyer, there are some certain duties that the law imposes on you. First, when you are approached, it is your duty to inform the other lawyer. I like to say that such duties is better, or information is better done through an email or WhatsApp message. I called him, he didn't call me. I called him, he didn't call me. Can cause a problem. But if you have it by a simple mail, he stays there. I informed him. Then the new lawyer must use his best endeavors to make sure that the old lawyer is paid his fees. The two lawyers, if it's a matter in court, the two lawyers must inform the courts. Here, what we usually do is the new lawyer is the one that informs the courts. Go back to the rules. The rules said the two of you will inform the court. The old lawyer needs to inform the court that you are no longer in the matter. The new lawyer must inform the court that is now in the matter. Then where the major problem is with this rule is client's documents. I don't know why lawyers find it difficult to use the client's document to him. Give back his documents. What is the problem? I want to say that from the experience I've had on this rule, the major issue we have on this rule that has brought lawyers to LPDC based on this rule is handing over the client's documents to him. Why are you withholding a client's document? Do not say you should hand it over to him. Take your money and hand him over his documents. So there are just very few rules for the lawyer. Very few, just four. 4 rules, just 4, which I've just stated. But these rules must be obeyed. I want to say, my closing remark is usually very simple. I've talked about sanctions. I'm of the view that lawyers should please go to Rule 1. The rule of the RPC is an omnibus rule, which is very dangerous. A person called a lawyer should be a person who is expected to uphold and observe the rule of law, promote and foster the cause of justice, maintain a high standard of professional conduct, and shall not engage in any conduct which is unbecoming of a legal practitioner. This rule embodies all the other rules. It is from this rule that the infamous conduct is founded. What it means is that the lawyer's behavior must be above board. In conclusion, I want to say that the duties explained and listed in RPC are laws Even though Christian duties, there are laws and they must be obeyed. And to wish us well by saying that we should simply obey the laws, the rules, and thank you. Now, this session is interactive and it's more like collapsing all the topics that we had, and then we address it in how we can use the image of the legal profession. Now, I want to drop some questions. I don't know who can help us with the mic, please. And then I'd like to have reactions. Then we have two lawyers here who can help us. Now, in summary, the overall focus is that is the lawyer who is alive that will adhere to the RPC. So can we say that when lawyers are underpaid or have action, it affects their adherence to the RPC? I don't know if you get the question. But the whole essence of the RPC is for lawyers to adhere to the RPC. And these provisions ordinarily are for those lawyers who are virtually, quote, alive. Alive in the sense that they don't have any capacity, because no lawyer would want to just deprive another lawyer of his clients or want to engage in ethical practices just for the fun of it. The whole goal is we want money, in summary, right? So is it that we need to improve our welfare, our relations as lawyers that can enhance our image of the legal profession? Who wants to try? And that's it.
Good afternoon, everyone. My name again is Jimmy Akonde. First of all, before I delve into this issue, let me first of all say to the for this initiative. And for me, what stands out is that everyone in this room is a leader in different capacities, and it's very good to bring together trainers that will go back and train people, in our various branches at various fora. So for that, I am very happy to be part of this initiative. But down to the issue, I think that two issues are two parallel lines. One is integrity. And for me, integrity has nothing to do with whether you think you're well remunerated or you're not well remunerated. That we call integrity goes a long way. I might not be in a very comfortable situation where I want to be financially, but I must still be in a position to obtain that those rules. As a common, once you agree to that call, has its own rules. Whether you made it, you haven't made it as a lawyer, I think you must comply with those rules. Now, talking about remuneration, I think that especially for young lawyers, I think, I think that this administration, and I see the trajectory they're going, and I agree with them in terms of wanting to improve the remuneration of young lawyers. Good enough, the current president was the chairman of the remuneration committee in the previous administration. So I think it's something that is very passionate about. So I am very confident that a lot will be done to ensure that our young lawyers, can earn a living wage. It's a challenge. It's always been a challenge for me. I was chairman of Lagos branch in 2020 from 2019 to 2021. My administration was young lawyer centric. And all I thought about was how are we going to improve the remuneration of our young lawyers? It's a difficult one because all that time, identify the fact that the issue of remuneration is an issue of contracts. You cannot compel. You cannot compel someone to pay certain amount of money. What you do is that It's like the president and the current administration did last year, was to carry out a survey to find out what is the living wage, so that you can then identify that a lawyer will do to see you can get to meet that. But the challenge, and we continue to have that challenge, because at the end of the day, it's the man that has enough that will pay enough. So we need, first of all, like I say, to the market, to the ports, the port, and the port, there's so much in the port, you can then think of young lawyers should be this way or should be that way. But it's a conversation that has started and should continue. I have a classic example I want to give to you. Now, and it's a question I ask most lawyers, especially when they come to me, because from time to time, I see aspirants to the bar come to my office wanting to sign the benchers form. I also mentor a lot of young lawyers, and I say to them this classic example: instructs you to recover 1 billion naira. Recover the money, you speak to me. Bank has not paid you your money. I give the bank that your fee is 250 million naira. Now your 250 and send 750 million to the bank, or it's an issue of personal conduct. If you speak what your own decision says, that it's a very dangerous proposition for a lawyer to say, I have deducted my fees from the money I recovered from you. I don't know you. And because they return money to them, and if you are going to sue them, you can sue for your money. But you cannot deduct your funds. So it's like, and out this issue, it's a personal conduct issue. I don't know if the panel can speak to that, but it's a trend. It's a trend. A lot of people are not aware of these things. They do it, and it's something that can land in to see. It's a very, very, very sensitive issue that will be brought to the front burner. Thank you very much for listening to me.
Thank you so much. While I will, if I call the man on black cap, who also wants to respond to that?
Hello. Okay. Okay, in reference to the issue Leonard Silk raised, Yemi Akande, on whether a lawyer can deduct his fees and then remit the rest to the client. I think that what a lawyer should do, a lawyer cannot do that. Let me say that categorically. What I think what a lawyer should do is, at the initial stage of securing your instruction, you can also secure an authorization or a document from the client authorizing you to deduct your money or empowering you to deduct your fee. And the fee has to be spelled out in liquidated sum. That way you are protected. The client cannot be offended that you deducted the money, because the challenge with lawyers and clients is that when you remit the entire funds, the client now goes away and begins to contemplate whether to reduce your fees or to renegotiate the fees with you. So in order to prevent that kind of, because that's what the lawyer is also trying to prevent in an unethical manner, by deducting the fees ahead of time without a formal instruction from the client. What I do personally is that from the onset, we agree on the fees. You issue me an instrument that is notarized, where you have expressly stated that I should deduct so amount amounting to so percentage as my fees, and remit the residue, which is either 75% or 90%, into your account with so name. So it is clearly spelled out. So I do not need to come back to you as a lawyer to start debating whether to take out my fees or not. Thank you.
Thank you so much. I think that makes sense. Before I call the man, please, man with the black cap. Yes. And before you speak, I'd like to drop the question for Chief Emeka to come on before he gives his answer. So I want to ask, I know you appear very young, not that you've been in the game for so long. Would you say that the issue of the RPC and its breach has been over time, there's a recent development of this breach. I don't know if you understand the question. Is it a time situation? Are lawyers more desperate than those of lawyers before now, or the economic situation is affecting our observation of the RPC? So, Mr. Mansa, your name and your contribution, please.
My name is Ibrahim Lawal. I'm the chairman, NB Ibadan. I want to state that the basis upon which we are called as lawyers is to uphold those rules of professional conduct. In fact, the major topic you do at the law school is to ensure that those things are rammed into your head. And when RPC is faithfully observed, the issue of economic problems and stuff like that will also be resolved, because it is in adherence to RPC that you know that you cannot go and hijack other person's cases. It is the adherence of RPC that will also tell you that you can't undercharge yourself, or you undercharge because you want to collect another person's grief. It also would also encourage one to know that if you are charged and the client goes to another person, it will still be the same or in the same range. It means that when we observe RPC as lawyers, it has a lot of advantage even to our well-being. But to say that because of economic situation, that is where we have breach of RPC, it's like trying to defend what is not. RPC is foundation of our being called a lawyer. It is that RPC that ensures that you must have integrity. You must, when you say A, it must be A. And without observance of those RPC, we are like any other person apart from being a lawyer. So I want to encourage us that what we should insist, like we do say at every of our meetings, is that people should carry along with them professional conduct in their dealings with clients, in their dealings with the courts, and in their dealings with their colleagues. If we do that, I can assure you that the image of the bar, our image as lawyers will improve and people will respect us more. Thank you very much.
Thank you so much. Chief Counsel.
Thank you very much. First, let me join in commending supported this program today. The chairman indeed of a truth. The professional misconduct is one infraction that does not only affect the counsel who is guilty, but it affects the entire profession. So a lawyer may commit professional misconduct and it will affect the lawyer in Sokoto. How do I mean? Headline is lawyer absconds with client's money. By the time you meet your client, he says to you, is it not you people that take our money away? So it affects everybody, and that is why this program is very important. Like Mr. Akombe said, it's a matter of integrity. And for too long, we focus on how does clients perceive us. But I think we should turn it around to check how our colleagues perceive us. In this room, I can tell you, if we are doing a matter with the council, and we know ourselves, and the council says to you, don't bother to come, you can send the junior lawyer and ask the court for adjournment. It's on the council. If some council tell that to me, I will go personally, because I don't trust him. We've seen it. We call a colleague and say, please, I'm unable to come to court. Can you stand down? My colleague will ask for a stand down and accepts that.
for the man to get to court and insist that the matter will go on. Those are the issues. And you cannot buy integrity. When you cannot give your word and the lawyer, your colleague takes your word for it, then there's a problem. Traditionally, I've not seen anybody charged before the disciplinary committee to come and say, I committed it because I couldn't pay my children's school fees. I've not seen that. So we should stay away from implying in any way that integrity has anything to do with the well-being of the lawyer. A lawyer who will cheat will cheat. How do lawyers perceive you? When we spoke about status, that we are all lawyers, today you go to court, you see a senior advocate, our colleagues, they come to few seats, take the front row, and across the aisle, the front row is still empty. Only one senior advocate. Instead of inviting other lawyers to join him, so they can also do their matter with convenience, they prefer to sit down and do his matter like a lord of the manor, and when he finishes, he'll go away. That is why some of our younger colleagues today do not give us the respect we deserve as senior advocates. Just last week on Thursday, I was before 49. In our the court came in. The first matter on the cost list. After the matter was number 4, I signaled to the registrar that I'm interested in number 4. The registrar called number 2. And the court attempted to proceed. I started grumbling. And when the court asked what is happening, one lawyer from the back said, my lord, there's a senior advocate here. And when did he say so? When I came in, I invited counsel to join me in the front seat. He said, my lord, there's a senior advocate. So when you get to the point where junior lawyers will not allow your privilege to be breached, then you know that we're doing something right. So I invite all of us to be conscious of your personal relationship with your colleagues. That is the foundation of RPC. If I know that the way I treat Mr. A will reflect back on me, we say it that respect is reciprocal. If you demand respect, you must show respect. And you must not show respect because of the status of the person. You must show respect to your colleagues as counsel. Thank you very much. Thank you so much. Secretary, I've got a 2 branch. And then secretary is executive branch. Yes, I want to say that I am very happy for this particular topic that has been brought out. I want to thank the learned person that just spoke. In fact, spoke part of my mind. See, the problem we have is lawyers. Some of us behave as if we are alter egos. Whether it's AM, whether very senior lawyer, or even some younger lawyers. It will surprise you that last 3 weeks we were in court. For instance, I came to court. Now, a senior lawyer too. I now told the lawyer, please, court has not started sitting. Let me go to another court. We have just served you. I know the case may not go on. Can we suggest some days, assuming I don't come early? Do you know what the lawyer told me? He now said, a very senior lawyer that is not less than 40 years. He now said, have you been to ask me to agree to? said, I need to do. I need to know from me. How can you say such a thing? You're not less than 35 years. So and how old are you? And we now said that. You see, the problem we have always had in our professional conduct is the way most of us live. So that this program will be done in a way most of us, including the most senior lawyers, and even come. And you see most of this is happening. Those of us who are litigation conscious, not into commercial practice. Because, for instance, I was doing a matter in Abuja here. I came. So those of them who have agents, agents in a hotel, 2 agents of 2 different lawyers came. And I came, not knowing that I am a lawyer that was handling the matter. And this is not the type of matter a lawyer who is not a senior advocate should handle. In my presence, my client was looking at me. And when we finished, he said, hey, did you hear me? You can go and choose now. Let us see what will happen. So, on the other side was a senior advocate. Unfortunately, we went to court. I told my client, come to court, don't worry, because he doesn't like coming to court. I told him, come to court. Fortunately, he came to court that day. And there was a motion to strike out the matter, which I filed. Sorry, I will soon be with you. The court had us. Then and then decided to strike out the matter. Who was. So, I'm trying to say, I'm not trying to disparage any person. But you should be very, very careful what you do. Because it is very, very important. And as you know these things, the younger ones are learning. Let's see. I thank you so much. I've heard about how you behave when you come to court. Never in actually, so when I'm one day on the money. I'm trying to say, as we are lawyers, we all know ourselves. Judges that take bribe, we know them. Most of them that don't take bribe, we also know them. So I want to say that it is important that we get ourselves, please.
Thank you so much. Sarah, make a point. We have just 5 minutes, so we'll go. Sarah, the chairman, Isioko, then I'll go here. Everybody is out.
Okay, thank you. Can I go on? Yes, good afternoon, everyone. Quickly, before I be perceived otherwise, I believe strongly in discipline and learning. But the question, even while the learning sick was presenting, he kept mentioning the wide and broadening discretionary powers that the LPDC has. So my question is there a possibility of no abuse whatsoever, considering taking the Nigeria factor into consideration? Thank you very much.
Thank you. Chairman, Super Branch. Over here.
Thank you. All protocols observed. My name is Simple Dion, Chairman Ishogo Branch. I want to thank ROLAC for this training. But one problem I observe is that apart from some senior lawyers who are interested in bar activities, The ones that come for trainings like this are usually MBA officials. And over 70% of legal practitioners don't come for this kind of program. Particularly those who taught litigating lawyers. And they don't hear all these things we say. It's possible for this kind of programs to be localized and made compulsory, and sometimes communicated to the chief judge of various states. When we are talking about IPC, one of the very first thing we said is that the Lord has honored his promises. I think that was one of the very first this thing. And as early as when I was going to have the president, situations in court. And I'll give you an example. I was very senior level. A trial. Find my claimant's reply. I'm thinking that he has filed his pre-trial processes. I promised him in the court. I have not done this. Can you take it? I will do something for your transport for today. And he accepted. But before I could get to my car, I sent me a damaging text message. My wife might not send the money. I was angry. And I said, okay, let's do it. It before I pay the money. For us to come the next date, I discovered that he has not even done what he is supposed to do. And instead of coming to court, he sent engineer. And I told engineer, I thought the principal had done what he was supposed to do, that I was the one paying. That taking it. So that's he was here and I don't know what to say. Now that has made me quite independent by the promise I made. Yes. The second issue is this: the issue of council. Council takes over. Now, both of you must go. Now, let me ask: supposing on the fine, and it's a place either you will find notice of change of council or you will go to court for your transport. Because that person that has collected the fine will not be ready to give you the transport with the this program, so understand reality. Thank you so much.
Thank you. Mr. Simple, for the first issue, I think there's a reason why chairman of branches and their wildlife chair were invited for this program. And the reason is this: you're supposed to go back to your branch and pass the message across during your monthly meeting. Just as Doctor has said that once you have an information as a lawyer, if you're in breach of that information, it's a misconduct. So for every chairman and your wildlife chair here, you've heard the good news. Please go back to your branch and pass the message before Doctor files a matter before the LPDC against you. Thank you. The man on red tie, please.
Yes, sir. Thank you, sir. I'm David Eze from Ole branch, Delta State. Sir, very briefly, I'm directing this question to Doctor, sir. That was affect our pocket too, not only compliant with the rules of professional conduct. Yes, sir. A client bought a landed property of 5 million naira. The client approached me first. I told him my fees is 10%, 500,000. He said he can't pay. He left. He went to another lawyer. Another lawyer wrote him for 20,000 naira. What can I do to petition such person to RPC? I mean, LPDC. I don't have evidence to prove. But the client came back and said, what you rejected, another lawyer wrote it for me, 20,000 naira. What must I do, sir? Thank you, sir.
Thank you so much. Please, we are pressed for time. I don't know if you have, let's just for equity purpose. Do you have anybody in this aisle? Okay, please, quickly. And then that's the last question for today, please. Okay. Okay, I'll take it because of gender balance, please.
My name is Honorable William Ewenodo, Chairman, Afro Branch. Mine is an intervention. I have observed that we've been asked repeatedly what do we do. So I would think, just like you said, branch chairman, as much as possible, we should liaise with the NBA National to see at regular basis. We invite you, not just at our meeting, because if you have a meeting of 2-3 hours, we cannot do sufficient justice to ROPC. So that let's see how NBA National could, as part of continuing legal education, I'm making a proposal, bring in all of these interventions so that gradually these messages will sink better to members, because you have said, like Dr. Obionu has said, that you have sent us a message. So we must divulge all of these contents at our meetings. It may not be possible, but we will do as much as we can. But let the MBA liaise with branches at regular intervals. We share this information to bring down the message. Thank you.
Thank you. Last question, please. The lady. That's the last question.
Thank you very much, Mr. Moderator, for the recognition. Good afternoon, everyone. I have two concerns to raise. One is with regard to the provisions of Rule 29 in the event of change of counsel. You know, we know two of the rules are like complementing each other. Like when there is change of counsel, the two counsels, that the new and the old counsel, has to come to the court and then notify the court. And they have to notify each other too. All right. When it comes to issue of payment of the previous counsel, that's the first one, at times it's not practically obtained between counsels. The new counsel may not, put more effort or emphasis in making sure that the previous counsel has been paid by the clients. Maybe they don't want to lose their brief or something. And then at times, the other rule that requests us to hand over all the client documents to the new counsel. You know, sometimes some counsel retain those documents because they are not paid fully by the clients, thinking that by withholding the documents, their payment will come. So how do we reconcile this first? And then secondly, about the issue of stepping down this training. You know, Roland said they are available to support. I want to know the type of support they want to give. Is it they want to sponsor the step down training, or they will only give the technical support? And if the events they're coming down to give technical support, who will be responsible for their movement, their accommodation, feeding, and everything during the step down training? Thank you.
Thank you so much. I think I will address your last point last. Doctor, while you try to address most of the question, I think one of the most key points is how do lawyers effectively go after their fees when they are disengaged by clients? Because I know the whole thing, just like Madam has said, is that the reason why most of them would want to withhold documents or pay from us is because the procedure to get their fees back is cumbersome. So do you think that we need to find ways or practical ways for us to be able to get our fees when we are disengaged by clients?
Okay. Thank you for the questions. I will start with one of the fee. He said that the lawyer charged 20,000 instead of the 10%. Let it be that I heard wrongly, but I heard you say you approached him first. I want to believe that that is wrong because it is not for you to approach. Yes. Okay. No, that's why I said I want to believe that I heard wrongly. So if he approached you first, and then he came back to tell you that Mr. A had taken 20,000. I know, I'm not very sure of the rule, but I think Rule 11 of the remuneration order, which is now part of the LPA, says that a lawyer should not undercharge. So it's an infraction of the rules. My advice will ordinarily be that I don't know how you are going to get the evidence, but it's an infraction of the rule. You will need to weigh your options, whether the client can prove it or not. But it's an infraction to undercharge under the rules. Then the issue of someone raised the issue of sanctions, that the sanctions are omnibus, and that Nigerian factor could affect the kind of sanction applied in a given situation. Well, as of today, that is the law. It is discretionary. LPDC rule 22 of the LPDC rules talked about the sanction. I had earlier said today that one thing you can do for yourself is to avoid LPDC because it's discretionary. Anything that is discretionary is dangerous. The punishment is discretionary. Avoid it by all means. The rules did not state if you offend Rule 1, this is the punishment. If you offend Rule 2, this is the punishment. If you break Rule 3, this is the punishment. The rule went and classified the punishments in one section. So there is the punishment section is just one for all the entire rules. So, and it gave the chairman, it gave the LPDC may. Any of them, they can choose any of the rules, any of the punishments. So unfortunately, that is actually the situation now. So we can't really change it. Then on the issue of change of counsel, I want to take the angle of handing over documents and your fees. The LPA made provision for how you can recover your fees. That is why we are saying, do not deduct your money at source. It is not your money. Do not deduct your money at source. It is not, do not deduct your fees at source. What you recovered is the client's money. It is the client's responsibility to pay fees. And where the client fails to pay fees, the law provides for how you can recover your fees, whether it is cumbersome or whether we consider it cumbersome or not. That is the provision of the law. For now, there are efforts to amend the LPA. When it is made public, do not shy away to bring up a memo if you have an alternative means. Now, we also have a problem. One of the problems we have is that we are not briefed in writing. We don't take our briefs in writing. So there is no liquidated money. We're not sure. It is what he said. I've always had a simple way of doing it. Once the client leaves my office, do him a mail. Most times the answer you will get to that mail is, okay, we agreed on so, agreed on so, please confirm that. He will just reply and say, okay. That's all. Print it out and clip it. That's an instruction. But we don't, most times we can't enforce because we don't have anything written down. How do you enforce? I don't know whether I've addressed the issue. Then on the change of counsel for people that live in, who pays the transports? Well, I think you should factor that transport in your bill, because it is what the rule says today, which is the law as of today, is that you must notify the court. Thank you.
Thank you so much. Mohammed, from the discussion, we need to know what ways that we have to enhance the image of the legal profession, practical ways.
Thank you, Benjamin. Thank you, Hayes. The image of the profession is our image. The profession is only as good as the lawyers are perceived. So how do we enhance the image of the profession is to enhance our own individual image. Together, we make up the profession. And I've heard it in this room that the idea, which is where I started with, is we have leaders of the bar in this venue. The idea is we can continue to talk about this. The rules of professional conduct are there, but we can continue to socialize it amongst ourselves with the aim to make sure that it takes roots in everything we do as lawyers, and to ensure that we better serve the interest of justice. So if we do that, if the branch chairman and EXCOs and YLF and the various sections and fora of the Nigerian Bar Association, if they undertake and they go ahead and replicate what is being done here in their branches and in their levels, then more of the word is being spread. And we are in our firms, in our respective practices, we undertake to do better and to be better ambassador of the profession. Something that is quite touchy for me is the issue of how much petitions we all write. We all have authored petitions to the police and to EFCC for matters that we all know should go to court. Now, you can argue that what you're trying to do is you're trying to get your clients to get their money quickly. But what this is doing is that all of us are becoming litigants, not before the courts, but before police, before EFCC, before ICPC. And those guys sit as judges, talk down on lawyers, say lawyers should shut up. It is the litigants that they want to speak, tell lawyers to go and wait outside. It's a worrying trend. It means more and more of the things that should go to court is going to extrajudicial fora. And it means more and more. Police and EFCC and ICPC are seeing more of us, disrespecting us, and we know what that means for all of us. It means the police can talk down on us. It means EFCC. I mean, I'm sure everybody has experienced some of what happens. So we need to realize that those small things that seem like small things, they snowball into the big issues we have to deal with. And it is for us to make those conscious efforts to be better and to carry ourselves better, and the profession will be perceived better. Thank you very much.
Thank you so much. Tosin, please, just to wrap it up. I think now that we have a robust RPC and then there are conversations for more engagement and review of some of these RPC and the laws, I think the issue of how to discipline lawyers will now come to play. Do you think that the current measures being put in place is enough, or do you think that we need to expand on how we should discipline lawyers that are in this RPC breach?
Thank you, Benjamin. I think the set of rules that we have at the moment for the regulation of the practice is robust enough. I do not think that there's any need for any extra legislation. I think the real issue we have is adherence. You know, that's for the LPDC. But for the lawyers, I would say, when you leave this event, please prepare for yourself an instruction form. It's a simple document that will help you regulate, formally and professionally regulate your dealings with your clients from the onset. You know, even clients that call you on the phone for the first time to seek legal opinion, you can send them a mail saying that you called me at 11:15 a.m. to 11:26 a.m. for so number of minutes. My professional fee for the advice that you requested, which has been provided, is so amount. You know, when you regulate your dealings with clients formally and professionally, it would limit the conflict, because the issues of misconduct always emanates from conflict with clients, particularly with issues pertaining to payment of legal fees. Most of the time, the client is not displeased with the service. It's always because of a dispute, most of the time, because of a dispute as to how much is to be paid or how the money is deducted. So please prepare for yourself an instruction form. Try to always document every dealings that you have with clients, and we can stem the tide of frivolous petitions so that the LPDC also will not be inundated and they can deal with real issues. Thank you.
Thank you so much. In conclusion, the last speaker also raised the same issue that chairman of Ziopo branch raised. And I still believe that some of these things can be trashed in your monthly meetings. For example, I know for my branch, we usually have knowledge sharing sessions, 15 minutes, 10 minutes. So you can make it part one. Take one of the rules, part one today, this month, part two, part three, and so on and so forth. I mean, if we have to wait for rollout to start sponsoring every branch engagement, I don't know how practical that would be. But I think for every monthly meeting, please try as much as possible to have 15 minutes, 20 minutes for knowledge sharing session where you can deal with these rules one after the other, right? I don't know if that's okay. And I think that will conclude the end of this particular session. Thank you very much for your time, and God bless you.
Thank you.
This is, I think this is the most of this today's particular workshop. So quickly, the picture session, national officers present, senior advocates of Nigeria, please come and join the panelists so we take a quick picture. Vice President, sir. Senior advocates of Nigeria, school, please, we need to take these pictures. While the pictures are being taken, we need to make a quick announcement. Earlier on today on the Channels platform, and I think on the wireless platform, a WhatsApp page was sent. It's supposed to track most of what we have done, and for the purposes of assessment by the I expect each and every one of us who has participated in this event to join that platform. Information will be posted there. assessment notes will also be posted there. Then anything concerning this training, going forward will be posted there. So please, branch chairman is on the platform, members of YLF is also on the platform. Please join that platform. Then as for the step down training, day two, has a plan for branches. You talk about the modalities, will tell you about the modalities, senses if necessary. Before we go to day two, assessments will be sent to the platforms, like I said, have to fill them. It is very, very important that everybody who participated in this exercise fills that link, because tomorrow is very, very key. There's a lot attached to that thing, so I don't want to overstate the importance of why that has to be filled. In the absence of any other thing, we need to start preparing to shut down. His chief of staff here, Barbara. So, the wildlife chairman, secretary, are they here? Okay. Wildlife chairman are here. So, chairman, we've heard about the wildlife council. The chairman of that council is standing there. Please come forward. They don't even know you. His name is Timothy Clemens. He's our brand new wildlife chairman. He's the chairman of the council. He's a round of applause from him. We all know his secretary, Osaba Agro, is up there. Now, the wildlife chairman has an announcement for his members, so he will quickly give that, then we'll close lunches behind you. That's in orderly manner. Then we'll adjourn for tomorrow.
Good day, distinguished seniors and esteemed colleagues. My name is Timothy Clement, the national chairman of the Nigerian Bar Association Young Lawyers Forum. Let me personally appreciate the organizers of this program. I believe that everybody has learned one or two things in the course of this program. To my esteemed YLF chairman of the various branches, please, after this program, we have a meeting for all YLF chairmen of the various branches. And I believe that the meeting will start immediately. Thank you, and thank you so much.
Thank you very much. Okay, before we close, there was an arrangement that was made, a private arrangement for buses for those who are going to Akure on the 5th. The coordinator for that arrangement is outside, so once you are done, please make your way to him. We are going to be serving lunch. I think that you could do that row by row so that we do not have unnecessary rancor at the back, too much the crowding. You can start serving lunch. We want to take time to appreciate each and every one of us for today. We'll try to rush all the events so that we could have a little bit of rest this evening, especially those of us who traveled all through the night. So we are very thankful for your presence here today. Tomorrow morning, 8 a.m., we are all here so that we can start in earnest and finish on time. Thank you very, very much. Thank you.
Chairman, how do we achieve, how do we achieve lunch without the noise? Is it possible that we can all take our seats and we'll be served well seated? Please, can everybody go back to their seats? People at the back, serving, please let's stop. Everybody, please come back to their seats. With all due respect, everybody come down to your seats. It's important that we do this real quick and then we'll leave there. Someone sit down, please. The earlier we sit, the faster we can start. Please can stop serving lunch at the back. Please sit. Please, let's have a seat. We are going to our lawyers now. Let's do this in an orderly manner. Can everybody please sit down? If you've collected, you can exit the auditorium, but let's all have our seats. Gentlemen, let's have our seats. Stop serving at the back. Our seats, please. It's important. We can't be having these people. Their cameras on. Let's all have our seats, please. Gentlemen, please have our seats. Everybody, please have your seats, please. Please have your seats. Hey, I said stop serving. If you are taking your meetings, you can exit the auditorium. A young lawyer, move to the front. Your meeting is starting immediately. Please, everybody, go to your seats. It's really important that we. Please, everybody should sit down. I mean, this is.
See, this portfolio, they don't listen because they are confusers.
Gentlemen, sit down now. Let's sit down. As long as we stand, we don't get anything done. Hello.
Okay.
This can settle be done real quick so that those who have to live with it. Seven, you are the one not delaying us. Please. Quickly. Government Council of the YLF, please come forward. Please come forward. Members of the Government Council of YLF. Chairman, sit down, please sit down. Be patient. We're just finished talking about RPCO, please. No. Please, once you get your meal, please exit the auditorium so that we can serve other people. Thank you. Chairman, please sit down. While chairman, please have your seats so that the people who are serving can do so in an orderly manner. I'm looking for. I've served. The mess of everything I'm saying. Doing fast now. I've already understood. I want to make sure this thing is being done. Please, I don't stop. They don't care. Anyway, they've gone.
There's some people have already gotten out. This sat down.
German, they don't think I want to come outside. Anybody has to come outside. Yeah, let's go outside. Hello, please. If you have been giving, please come outside. German, really.
If I see why we put that on, I will trust.
If you have been said, please come out. I beg. Thank you. No problem. There's a link where some everything. Hello, please come outside. Let's start. Have you gone? Fine, I'll come down. Come down. And come outside. You want to come outside. Hello, sir. Your body is come outside. Hello. Are you wired? You wireless. Sit down here. Hey, wireless, sit down here. Wireless. Yes, sir. Now, we said, please leave the auditorium. I'm seeing people walking around with bags. Please leave the auditorium if you have been served. We don't want people on the aisle at the back, please.
What do we say? That's what I'm saying now. Why you people that take out yourself? Why you why you come there suspend us? I told everybody to sit down. Why is it hard to that? I said everybody sit down. That's what I said. Why do you leave up there? No, some people up there. No, we're done. Please, let's go out. Let's go out. Okay. I'm not video. Yes. No, the other time I sent the message. The last thing. The other time, just let me know this thing out. If I don't do that.